bond amount on the violation of probation.
Very well. Does the state have any input as to the amount of bond?
The state would request $5,000.
State's suggestion is 5,000. Is that acceptable?
And Judge, that would be acceptable to us if we were able to communicate with Mr. Laughlin. We might have been able to do that beforehand. So I apologize to the court, but
No, you're fine. You're fine. You know, your client's still on community control, so once bond is posted within 1 business day, your client has to report to DOC probation.
yes, Your Honor.
Bond is set at 5,000 cash surety. Court date, Madam Clerk, when would the court date be?
As of now, it's April 22nd at 9 a.m. in front of Judge Crawford.
Yeah, and y'all may want to check with Judge Crawford to see how this matter should proceed in the event we're still proceeding under the administrative order.
Absolutely. Yes, Your Honor.
Right. Have a good afternoon. And you know, you could have always appeared here. You know that.
Right. I thought it would be better to be here so I could speak with Ms. Stifel, Judge.
That's fine. Thank you.
All right. Thank you,
Y'all
Judge.
have a good afternoon.
You too. Thank you.
State of Florida versus Hepburn, number 17.
How you doing, Your Honor?
Good. How are you, Mr. Hepburn?
I'm okay.
The charges, you've got 2 misdemeanor charges here this afternoon. One charge is trespass, the other is resisting arrest without violence. Are you able to hire an attorney, Mr. Hepburn?
No.
He qualifies.
No, Judge.
Okay, well, let me have you and everybody else who's about to address the court raise your right hand.
Everyone raise your hand.
And go to the
Ladies.
Can everyone please raise their right hands? Do each of you swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Very well. At this point, I am going to go ahead and appoint counsel for you, sir. Since you've been found to be indigent, I do find probable cause for your arrest. Court date is April 20th, 9 o'clock, Judge Brown, for arraignment.
Judge, may I?
Now, as far as bond, I'm going to ask about bond, right? What says the state as to bond, and then I'll hear from Mr. Hepburn's attorney.
The state is requesting $500 for each count.
To Mr. Hepburn's counsel, 500 per count sufficient?
Judge, I would ask for pretrial release.
He resides down in beautiful Miami-Dade.
No, I live on. That's what I wanted to say to you. The house that I got arrested at was my sister's house, and I was not trespassing. She invited me, and she even gave me pants to wear. I was reading the Bible when all this happened, and I was just telling her I'm being persecuted. I was praying to my God, and then the police came in because I wasn't answering. They knocked me off the chair and they tased me like 1,000 times. That's how it happened. That's all happened. I didn't do anything.
Well,
I can show you my
where
back.
Are you gonna be,
I can show you my back if you.
Where- no, I need to know where you're going to be living.
I have a place around the corner from my sister.
From your sister?
Yeah.
Okay. State any strong objections to pretrial release based on the facts here?
No, I don't have an objection, but I do want to make sure that he stays away from
That address.
the address.
Mr. Hepburn, I'm going to go ahead and adopt your attorney's recommendation. Given the facts involved, release you on pretrial release. You've got to provide them a valid address, but you can't go back to where you're arrested, which is 485 Canaveral Groves Boulevard, City of Cocoa. You understand that? Yes?
Yes, sir.
Very well. Good. Have a good afternoon, sir. State versus Locuson.
Yes, sir.
Name, please.
Boyd Edward Locuson.
Ms. Locuson, you here charged with burglary dwelling, possession of firearm by convicted felon. These are both felony charges. Are you able to hire an attorney?
Yeah. I'm going to get one,
The court will-
and it was placed in there by my family, and I'll get to the bottom of this with my family in
Okay,
court.
so Okay. At this point, I'm going to honor your request, not appoint counsel for you. I have read this report. I do find sufficient probable cause for your arrest.
fine with
Set your case for arraignment May 5th at 8 o'clock before Judge Ingram.
Yep.
Has the state heard from the property owner?
No, Your Honor.
State's recommendation on a burglary dwelling charge?
15,000 for each count.
Ms. Locuson, the bond, I'm going to adjust that because the charge is burglary involving a dwelling, and there's also a charge of possession of firearm by convicted felon.
Yeah.
Bonds will be set as follows: 15,000 on count one, 15,000 on count two. Are you sure you're able to hire counsel?
Not really, but I got time. I need some mail. My brother
If
took
you- if
most
you-
of it,
If
and now
if you
she's
change your-
taking my checks.
if you change your mind and you want the court to reconsider appointing counsel, bring that to our attention. Okay?
I will.
Thank you. Have a good afternoon.
Thank you.
State versus Ramos. Mr. Ramos, at this point, did you complete a financial affidavit for the court?
He did, Your Honor, but he does not qualify by about $300 biweekly.
300 biweekly. I'm going to go ahead, given the nature of the charge, find him to be partially indigent and appoint counsel for Mr. Ramos here this afternoon.
Yes, sir.
Okay. Mr. Ramos, I want you from this point forward to merely allow your counsel to speak on your behalf. Any statements you make, those statements are being recorded and can be used against you at your trial. To Mr. Ramos's counsel, do you all have a copy of the arrest warrant?
I do, Judge. I see that the judge that signed it endorsed no bond. However, I would argue that under the Florida Constitution, Florida statutes, and rule of procedure, he is entitled to bond.
Now, should I go ahead and read the charge, or are you waiving the reading of the charge?
I'll waive reading of the charge.
Okay. This is a life felony, or felony punishable. Is that correct, State?
That is correct, Your Honor.
So, over counsel's argument and objection, the court respectfully at this point will notate no bond in this matter, find probable cause based on the affidavit and the warrant in the court file, no contact with the alleged witnesses, Javon Thompson and Lucas Mann. Set this matter for arraignment May 5th, 8 o'clock, via courthouse before Judge Ingram. Anything else requested by the state?
No, Your Honor.
Also, no contact with the alleged victim with the initials T.M. With that, sir, have a good afternoon. Number 31. Mr. Woodman.
Yes, sir, Your Honor.
Good afternoon, Mr. Woodman. You have two cases before the court. In 2020 CF 23024, you're charged of possession of controlled substance. In the companion case 2020 CF 23028, it's the charges introducing contraband into the jail facility. These are both felony charges. Can you afford a lawyer? Should I appoint you a lawyer today?
No, sir, I cannot afford an attorney. Please
He
appoint one for
qualifies.
me.
Office of Public Defender appointed for Mr. Woodman on both matters. Anything I need to know on behalf of Mr. Woodman?
Well, Your Honor, I'm taking care of an older person right now that's very ill. I'm personally the only person that's basically getting their meals for them. I would ask the court if I could please be placed on PTR or PTI or ROR, and I will have no problems reporting to whatever court dates you assess me. Thank you. I have not been in trouble in quite a few years, Your Honor.
Does the state agree to pretrial release?
No.
At this point, the scheduled bond sufficient?
Yes, Your Honor.
Mr. Woodman, respectfully, at this point, pretrial release would not be an option. Probable cause is found for your arrest as to both charges.
Yes, sir. Your
Bond
Honor.
is set at $2,000 per case. Both cases are set for May 5th, 8 o'clock, via Courthouse, Judge Ingram for arraignment.
Thank you.
Okay? Thank you. Have a good afternoon. State versus Davis. Ms. Davis, good afternoon. Your full name, please.
Christine Davis.
The charges are 2 misdemeanors. One is reckless driving. The other is driving under the influence. Would you like the court to appoint counsel? You plan on getting private counsel?
Can I have counsel now?
She qualifies.
And, okay.
Yes.
I can always change it
Yes,
at a later date?
Yes, you can do that, yes. The court will appoint counsel for Ms. Davis to the Office of Public Defender. I've had a chance to look at this file. I do find sufficient probable cause for your arrest. Arraignment date is April 21st, 9 o'clock, Judge Jacobus v. Airport House. I am somewhat concerned about the allegation by other witnesses who may have witnessed a vehicle driving on the wrong side of the roadway before law enforcement made the traffic stop. What is the state's position?
500 for each count, Your Honor.
That's sufficient. Defense accepting 500 per count?
Judge, I see she has no prior convictions. I'd ask the court to give her a chance on pretrial release.
I respectfully, given the facts involved here, I'm going to go ahead and keep the bonds as is, 500 per count. No driving unless Ms. Davis has a valid Florida driver's license. No possession, usage of any alcoholic beverages or illegal substances. With that, good luck with this matter, Ms. Davis. Thank you.
Thank you.
State versus Hamilton. Strike that. State versus Nice.
She's been released on PTR, Your Honor.
Oh, okay. State versus Foster.
Foster.
Mr. Foster, good afternoon.
Good afternoon.
You had a lawyer to the Office of Public Defender previously. The charge today is violation of your probation. Would you like me to reappoint them?
Yes, please.
He qualifies.
Office of Public Defender appointed. Did you get a copy of the warrant?
Are you asking me?
Yes.
Yeah, I received a
Do
copy.
you have it? Okay, very well. As you can see, it's no bond. Any special designation, State?
No, Your Honor.
Mr. Foster, it's no bond. Your case is scheduled for arraignment May 11th, 1:15 before Judge Lemonitis.
There's no way I could request a bond on this?
At this point, you need to address that with the trial judge, the Honorable Judge Lemonitis. Okay, thank you. State versus Gibson, number 11. Mr. Gibson.
Good morning, sir.
Good afternoon, Ms. Gibson. How come you missed court back in September?
Your Honor, I work for Advanced Disposal, and I stay in Jacksonville. I never received any mail from anybody at my residence. Even though I moved, they take $133 a week out my check, and I never received no mail from anybody to come to court. I'll be in Melbourne at least twice a month to see my daughter, and I was never notified by anybody I had to even come to court. They picked me up from work and told me that I contempt the court here, and I'm like, I never got a letter or anything from anybody to come to court.
Well, they sent out the notice back in August, it looks like.
I never received it.
Okay, well, I'm going to go ahead with your assurance that you're going to show up for court. I'm going to give you a court date or release you.
Yes, sir.
If they're taking money out of your paycheck, check with Department of Revenue to see if that could be addressed. So,
yeah,
that's.
I talked with the lady in Melbourne, and they just took $17.49 my income tax in January, and I don't know how I can be behind when I'm paying and they're taking money from me.
Well, that's what I'm saying. You need to speak to the child support folks and address this issue with them. So I'm going to go ahead and release you today. Please show up on April 20th at 1 o'clock, Melbourne Courthouse, hearing Officer Perez.
You'll get, hang on, you'll get that paperwork.
I want to write it down.
No,
Okay.
they'll put all that in writing.
Okay.
But Mr. Gibson,
Yes, sir.
check a few days beforehand to make sure that that hearing's still going to take place or if it's going to get continued.
Yes, sir.
Okay?
Yes, sir.
All right. Have a good afternoon. State of Florida versus Hamilton, number 14. Mr. Hamilton, your full name, please.
Charles Henry Hamilton III.
The charge before me this afternoon is an arrest for battery, domestic violence involving your spouse. Are you able to retain private counsel, or should I appoint counsel for you?
If you could appoint counsel.
He's actually non-indigent, but by $18 biweekly.
Okay. I'll go ahead, find him to be partially indigent, appoint counsel for Mr. Hamilton to the Office of Public Defender. Probable cause found, arraignment date is April 20th, 9 o'clock, Judge Brown. Has the state heard from the alleged victim?
No, Your Honor.
State's recommendation?
$500, Your Honor.
500 acceptable?
Yes, sir.
Yes.
Okay. Bond is set at 500 cash surety. No contact with your spouse, please, while this case is pending. If you wish to have it modified, file the appropriate pleadings before Judge Brown. You understand that?
Yes, sir.
One-time return with law enforcement to pick up your personal effects.
Okay.
Very well. Have a good afternoon.
Thank you.
You're welcome. State versus Langdon. Number 19. Ms. Langdon, your full name, please.
Daniel Wayne Langdon, Jr.
Ms. Langdon, you here charged with burglary, dwelling, occupied, and criminal mischief. The first charge is a felony, the second charge is a misdemeanor. Are you able to hire counsel?
Oh, sir.
He qualifies.
Office of Public Defender appointed. Now, I had a chance to look at this file. My notations reflect the location was not occupied at the time.
That's correct.
So it should be straight burglary.
Right.
It's burglary, unoccupied.
Unoccupied, right. Okay. So we'll correct the record to reflect burglary, dwelling, not occupied, or unoccupied. I do find probable cause for that charge. Probable cause also found for criminal mischief. Court date is May 5th, 8 o'clock, Judge Ingram. At this point, what says the state?
As to the burglary of the dwelling, the state would request $5,000, and for the mischief, $500. However, Mr. Langdon is out on two pending cases. Case number 2019509 CFA and 2020409 CFA. The state is requesting revocation of his bond in both cases.
Counsel for Mr. Langdon, any recommendations?
Judge, as to the new case, I would stipulate to those bond amounts. As to the existing cases, I would object to the revocation of those bonds. The state has not filed a motion at this point. We'd ask for a hearing with the trial judge.
At this point, the court, having reviewed the file, the defendant as to 2020 CF 19509, posted a surety bond on March 23rd. Here we are on April 2nd with the burglary of a dwelling charge. The court, pursuant to 903.04714 statute, will sua sponte revoke the bond as to the charge of possession of meth, resisting arrest, and battery in case number 2020 CF 19509. As far as the second case number, state respectfully, the court is not inclined to revoke that bond. However, as to the charge of burglary dwelling, this is a serious charge, and the basically bond will be set at $15,000 on count 1, $500 on count 2. Thank you, Mr. Langton.
Just step up.
State versus Miller. Mr. Miller?
Yes, Stephen Miller.
Ms. Miller, you're here charged with battery, domestic violence, and also aggravated assault with a weapon.
I didn't have a weapon, and they don't have one neither. So is there a way for it to be lowered?
Mr. Miller, this is not the first time you're before the court, so please follow the courtroom protocol.
Yeah.
I'm merely explaining to you the nature of the allegations against you. Would you like the court to appoint counsel for you?
Yes.
He qualifies.
Office of Public Defender appointed for Mr. Miller. Has the state heard from the alleged victim?
No, Your Honor.
As to the issue of probable cause, any argument?
Can I be released?
Judge, my argument on the aggravated assault, the 923 is thin as to that charge. The only mention is that Mr. Miller allegedly punched his father in the face and threatened him with a kitchen knife, but it doesn't give any other details on how he was threatened with the knife.
State?
If my memory serves me correctly, the argument was over drugs, number one, and or his defendant's alleged use of drugs, and the father felt that he was in danger at the time. He said
Well, why didn't he call the cops until like
he
a day
advised that he did
later?
not know where the knife was. It was used to threaten him, so he was threatened with a kitchen knife, punched in the face and with a kitchen knife. So I think that covers the PC issue.
Okay. Now, Mr. Miller's out on charge of violation of probation.
The state would revoke his bond in that matter.
All right, Mr. Miller, what I'm going to do is find probable cause as to the charge of battery, domestic violence. Even though I do understand your counsel's argument, there is sufficient, for today's purposes, facts as alleged to show the offense of assault, aggravated assault with a weapon, with a knife. Court date is May 5th, 8 o'clock, Judge Ingram for arraignment. Now, the issue I have, Mr. Miller, is that you are facing a charge of violation of probation for the offense of improper exhibition of dangerous weapon and battery, very similar to the issues at hand.
What do you want me to say?
For you, I guess he will be retaining you. Mr. Odia, you have two choices. I can either set the bond now, or if you would like, I can put this off till tomorrow, and so Mr. Ecker can be available. What would you like?
I'd like to set a bond today, ma'am.
Okay, thank you. Thank you, Mr. Ecker. Okay, let's see now. The problem here is, Mr. Odia, you have 3 prior DUIs, which means you're a danger to the community. I don't know any other way to put it if you're actually guilty of this charge. I did see that there was a refusal on this. And then you were also driving without a license, presumably because of the DUI. So I do find that you're a major danger to the community. I'm going to order, this is your 5th DUI. I'm going to order $50,000 on count 1, and 2,000 on count 2. And there'll be no use or possession of alcohol or illegal drugs, and pretrial release as a condition of the bond with random testing at your expense.
Yes,
Good
ma'am.
luck to you, sir.
Thank you.
Unless someone, nobody objected, I assume there was no objection. Okay. Hannah Van?
Hanif.
Hanif, I apologize, sir. Mr. Van. There we go. Sir, you're charged with a violation of probation.
Yes, I
Just
understand.
one thing. Sir, are you asking that I appoint an attorney to represent you?
Yes, but I have something to say. This is not pertaining to my case or anything. I came in Sunday, and I haven't been to court until today. They lied and said I had a medical issue. I got maced when I came in because my mask came off.
Okay.
And today is Thursday, and I'm just now coming to court.
Well, there's nothing I can do about that. You can file a complaint with the sheriff's office.
Yes.
Okay?
Yes, and
If
I
you
know it's
choose-
not. I know it's not going to be a bond on here, so I need a public defender, and you have a blessed day.
I'll appoint a public defender, and as you said, there's no bond.
Yes.
Good luck to you, sir.
And he does qualify, Judge.
Thank you. Marilyn Dowling.
All right, good luck to you.
Hello.
Good afternoon, Ms. Dowling.
Hello. Good afternoon.
Deputies, can you keep it down, please?
Yes, Your Honor.
Ms. Dowling, you're charged with battery domestic violence. Are you asking that I appoint an attorney to represent you?
Yes, ma'am.
She qualifies.
I'll appoint the public defender and I'll order pretrial release. Was there alcohol involved in this one?
No, ma'am. Absolutely not.
Okay. I'll order pretrial release with no contact with the victim, no return to the location, except one time. You need to go back there once to get your personal belongings?
Yes, ma'am.
One time return with a law enforcement officer to get your personal belongings, and no weapons, firearms, or ammunition.
Yes, ma'am.
And good luck to you, ma'am.
Okay, thank you.
Assume there's no objection there.
Thank you.
Destiny Reese.
I believe that's Destiny Reese. Here she is, Your Honor.
Destiny Reese, I apologize.
It's all right.
Good afternoon, Ms. Reese.
Good afternoon, Judge.
Ma'am, you're charged with battery domestic violence. Are you asking that I appoint an attorney to represent you?
Yes, ma'am.
She qualifies.
I'll appoint the public defender and I'll order pretrial release. No contact with the victim, no return to the location. Do you need to go back one time with the law enforcement officer to get your personal belongings?
Yes, Your Honor.
Mr. Ramirez, the boyfriend, contacted the state, and he states that he's not afraid of the defendant. He would like no unconsented contact with her, as they have children in common or child in common, and they do not live together.
Do you live with him, ma'am?
I did, not anymore. After this incident, I went to my mother's house.
Okay. Is it your husband? He's
Boyfriend.
asking for no one. Is that
Ex-boyfriend.
correct? Your ex-boyfriend, but you have children together. Is that correct?
Yes, ma'am.
Okay, he's asking for no unconsented contact instead of no contact. So that means you can have contact as long as it's okay with him. And there's no reason you need to go back there one time then. And no weapons, firearms, or ammunition.
Okay.
All right?
All right. Thank you,
All
Your Honor.
right. We don't need a no return then, right?
That's correct.
Okay. Good luck to you, ma'am.
Thank you, Your Honor.
Hannah Johnson.
Ms. Johnson?
Good afternoon, Ms. Johnson.
Good afternoon.
Ma'am, you're charged with petty theft. More than 100, less than 750. Are you asking that I appoint an attorney to represent you?
Yes, ma'am.
She qualifies.
I'll appoint the public defender. She does have a lot of pending charges, but I'm not keeping him. I'll order pretrial release. No contact with the victim. That's anyone who works or lives where this occurred. No return to the location. No contact with the co-defendant. No weapons, firearms, or ammunition. Anything else the state's asking for?
No, Your Honor.
All right. Good luck to you, ma'am.
Thank you, ma'am.
Ms. Ortiz? Ms. Ortiz?
That was her. Miranda Ortiz?
Yes, ma'am.
Ms. Ortiz, you're charged with a violation of probation on 2 separate cases. Are you asking that I appoint an attorney to represent you?
Yes, ma'am.
She qualifies.
I'll appoint the public defender on both cases. Is she AMA?
She is.
Okay. You qualify under the Anti-Murder Act on both cases, and there's no bond.
All right. Thank you, ma'am.
Good luck to you. Suzanne Wagner. Wagner. Good afternoon, Ms. Wagner.
Good afternoon.
Was there alcohol involved in this?
No.
No. All right. Ms. Wagner, you're charged with battery domestic violence. Are you asking that I appoint an attorney to represent you?
No.
Are you going to hire private counsel?
Yes.
Do you know who you're going to hire?
Yes.
Do you want me to call them for you?
Sure. Yeah.
Who is it?
Michael Gibson,
Where is he located?
Escambia County, Santa Rosa County.
Okay, you're gonna hire him for this case.
Yes, I wasn't aware I was going to have to. Okay. I think.
Do you want me to call him? I will. We can look up his phone number.
I know his
Unless
phone
you
number.
know it.
Yes, I know it.
All right, go ahead.
850.
What is it?
850-572-5992.
Okay, thank you. I'll call him right now.
Hello?
Is this Michael Gibson?
Yes.
This is Judge Atkin. I'm calling from Brevard County. I have standing before me at the jail Suzanne Wagner. She says she's going to retain you on this case.
Okay.
I'm about
Yeah.
to set a bond. I'm inclined to order a pretrial release unless the state objects.
No, no objection.
All right, I'm ordering pretrial release. There'll be no contact with the victim, no return to the victim's where the victim lives or works. and no weapons, firearms, or ammunition. I assume you don't object to that, Mr. Gibson?
No objection.
Okay. Ms. Wagner, did you hear? And
Yes.
now Mr. Gibson is aware that you're here.
Yes, thank you,
Your
Mr.
next
Gibson.
court date is currently set for June 10th at 1:30 for an arraignment. So I assume you know what to do, Mr. Gibson.
Yes, I'll take care of that. Thank you.
All right, thank you. Have a good day.
Okay, thank you.
Okay?
Thank you.
Stephanie Waters. Good afternoon, Ms. Waters. You're charged with a failure to appear. Are you asking that I appoint an attorney to represent you?
Okay, yes? Yes.
She qualifies.
I'll appoint the public defender. What does the state want me to do with this?
Judge Brown said a $2,000 bond.
Yeah, well, I can change it under the circumstances. What kind of paraphernalia was it?
It's it's PTR's fine.
PTR is
So
fine?
yeah, no bond. Yeah, I mean, ROR is fine. I didn't realize it was a drug paraphernalia. But,
Should I do drug testing or anything?
well, yes, the PTR with drug testing.
All right, I'm going to order pretrial release with no use or possession of illegal drugs and random testing at your expense. And Ms. Waters, make sure you show up for court, okay? It's on June 12th. At 8 a.m. Do not miss court.
Yes, ma'am.
Okay?
Yes, ma'am.
All right. Okay, good luck to you.
Thanks.
That's the end of the take out of order list.
Yes, Your Honor. Could we get about 5 minutes to get the next group in, and then I'll let you know when they're in, and you can swear them all in, Your Honor.
Okay, thank you.
You're welcome. Yeah, we're on a 5-minute break.
You'll get your own little method to your madness. Yeah. And that's what it is. It's just a flow where you look at it and you can follow it yourself. You know what I'm saying? And you can it's like a flow. So you know where you need to go. And I've done this, I've done this, I've done that, and then I go to this. You know what I mean? Once you get your own little pattern and system, you'll be fine. Trust me. And then you'll get so confident with yourself. Then you're gonna start. Then you're gonna think, oh my, well, I think I forgot something, but you didn't because you did it because it's almost second nature. Okay. You know what I'm saying? I do that all the time. All the time.
We let her know. I'll let her know.
I know why she's there. Let her know what. You didn't say.
Oh, goodness, girl. On this one, now you have the two of those orders out there.
I thought you said I didn't have it there.
No. You had the order, you didn't have the PD and whatnot. You had the order.
Oh, I thought it said all.
No. Well, it kind of does. Yeah, but you had the order.
Okay.
So just remove one of the orders.
Okay.
Yeah. One of the
That's sad that she knows though. No, she didn't say what county. I want to affirm the NBC status. I do not want it. You're right. Because I don't have a form. I don't believe it's right. That's what it is in the back of my head. No,
No, it's, trust me. Like I said, once you get your own little pattern, you'll be fine. You'll know.
You will. Yeah, yeah.
It's just like I said, you'll get to the point, because me and Nicole do it. We get to where it's almost automatic.
Yeah.
And then you're like, oh shit, did I do that? Did I put that? I don't know if I did that or not. But you do it so automatically that you forget.
Yeah.
It's like autopilot, yeah. Like how you get home from work and you don't even know how you got home.
Yeah, I do it all the time. And then I feel scared. I'm like, did I hit it? Okay. Mr. Adia, I put the PTR on all counts, right?
Yeah, it's fine.
Okay.
You know, you said as to all counts, but you could just put all counts or count, you know.
Okay. Very good.
It's not yours, but when you are talking about the PTR order,
Yeah.
I think you're supposed to write the numbers, so. Because if they file information and they add more counts, then.
I'll get that one back.
No, okay. I still got it up here.
No, I already processed it.
No, this one right here.
No, if it needs to be amended, I'll do it.
That one we wrote numbers. I think counts 1 and 2. The one I got in my hand is the one I'm asking about.
Oh.
PTR.
Okay, so I sent that one back too?
Yeah. So I need to put counts 1 and 2.
Yeah,
I
you
mean,
need to
1 and 2.
specify the count. If it's like, you can put like 1 through 6, or like, 1 through 2, and 4 through 8, or whatever. But you can't put all counts.
Oh, okay, for PTR.
Okay.
Because if they file an information later, then it's not clear what counts are on PTR for.
That is very good to know, Nicole.
I got told that.
Okay.
Yeah, because I didn't even think about it, to be honest with you. I'll just be honest. See, we all were.
Was it? Thanks for making sure I use the
No worries. I don't feel like doing amendments.
Oh, that's right. I was saying that too. I mean, like, I think
But I try not to be. I just don't want to do amendments.
for me, I think I should do it. So I can see how I'm stepping up.
That's all good. Like I said, there's no fault. All right, where are we at? Two of these. Where did I do?
I see it twice.
I'm gonna delete the first one.
Yeah, that's not good. I think that's the, yeah, I had that first. Oh, it's me. I forgot to say something. Yeah. Nope.
He said, I can't tell.
Yeah,
I can't
it's
tell.
my fault. I told her as soon as she walked in, I was like, oh, sorry. Sorry, I get them all back. Just reprint to them, right?
Yeah, you can print just.
Yeah.
Okay.
That can be done later. She doesn't need to do it right now. Make sure you know which one you did.
Oh, no, it's over there.
Which one's over there?
I'm seeing if I have any up here. Here's one.
Okay.
Legend. But you're still doing stuff.
Yeah.
Totally done.
Your Honor, We're ready.
She's gonna have to do two swear.
Okay.
Your Honor, these folks are ready to be sworn in.
Right in the courtroom. All right, thank you.
We're now back on the regular docket.
All right, thank you. Good afternoon, ladies and gentlemen. We are here for initial appearances. The purpose of this hearing is to determine if there was probable cause for your arrest, what your bond should be, and whether an attorney should be appointed to represent you. You do have the right to remain silent, so wait and speak with your attorney in private about the facts of your case. You also have the right to be in contact with your attorney or family by telephone. If you are here on a warrant, whether it is for failure to appear, violation of probation, or an arrest warrant, the judge who issued the warrant has already set the bond amount, and you will generally need to appear before the judge assigned to your case to request a modification of the bond amount. Will everyone who's here for court today please raise your right hand? You swear or affirm testimony you will give will be the truth, the whole truth, and nothing but the truth. Let's hear from all of you. Yes?
Yes.
Okay, thank you.
Mr. Peters?
Okay. I guess we're starting with Mr. Peters. Is that correct? Good afternoon, Mr. Peters.
Good afternoon, ma'am.
Sir, this is an out-of-county arrest out of Indian River County. Has the state had contact with Indian River County?
We have reached out to Indian River County, they have not responded yet. Continue on.
When are you asking to continue this till?
Next, the 21st.
Okay, we're going to continue this till April 21st for the state to have an opportunity to contact Indian River County, or they already contacted them to hear back from them to see what they want to do.
Yeah, yes, ma'am. They've given you, I was here 3 days ago. You gave them 72 hours. They have not responded, and also they sent a letter saying they were not transporting at this time.
Okay, is that what happened, mister?
It's what happens with everyone. It gives me 3 days, I asked for 3 days. The fact is, we're not picking up anyone at this time, but actually, the next case is on the docket, example of us reaching out to another county and calling you county.
Okay, but they've had 3 days to respond to you and they haven't responded.
Yes, that's true.
What is the charge here?
It's, I want to say it's a felony, give me a second.
VOP, ma'am.
You know that.
I don't know.
I'll just look.
If it's
It's felony.
okay, has the judge ordered the no bond on the VOP? Okay, so there's no bond on the VOP. We will set it again for 421 to see if the judge assigned to the case has set it at no bond. But we will set it for 421 to see if Indian River County wants to have Brevard County take any action on the case.
Well,
during the COVID-19, the counties are doing things for each other.
Correct. So with I guess my question is to you, ma'am. What was the previous 72 hours for then? If nobody responded, what was that 72 hours set for? You're just giving them another 72 hours to do nothing again.
Okay, I am giving them another 3 days, yes. Given that the judge in the case did set this at a no bond. What was the underlying charge?
It's trespass to occupied structure and third-degree grand theft.
Okay. All right, well, that's what we're doing at this point. The judge on Monday or Tuesday will have to decide what to do at that point. Okay, good luck to you, sir. Can you, Mr. Lockman, attempt to contact them again, please?
Absolutely. No, we do this routinely, and it's just been getting back to us. Yeah, you know, and then they have to, just so you understand, then they have to contact, assuming he's whoever beat the defense attorney, PD or whatever, they then have to contact the up with some solution. So that's why the process is.
Right, but it sounds like it hasn't gotten off the first step, so.
Again, we reached out, we just haven't had anybody get back to us.
All right. What is your name, sir?
Dennis Cherbiaco.
Hey, Your Honor, we skipped Mr. Carlos Prohia because he speaks Spanish, and we're going to have an interpreter, so we're going to have to do him at the end.
That's fine. What happened to my finger? What happened to my finger? Oh, there it is. It's on the floor. Excuse me. So your name is, tell me again, sir?
Dennis
Mark.
Cherbiaco.
Okay. I got it. I have it here now, sir. Thank you. Sir, you're charged with felony child abuse and battery domestic violence.
Yes,
Are you
ma'am.
asking that I appoint an attorney to represent you?
Yes, please.
I can have a minute, Judge.
Sure.
Judge, he makes $600 per week with 2 dependents, but he also has $6,000 in equity in a vehicle.
What kind of vehicle do you have?
Infinity G30.
What year?
2000.
What year?
2005.
Okay, you have money on it?
No, ma'am.
All right, but it's a 2005. That means it's a 15-year-old car.
Yeah. It's Infinity FX35.
So okay. I'm going to find that there isn't $5,000 in equity in it.
I just got a loan for $5,000 for that car, and I paid it off. Just saying.
Okay.
It's a racing
Right.
car. It has a lot of in there. That's why it cost on my dog.
Sir?
Yes, ma'am. It's not the issue, ma'am. It's not the problem here.
Okay. I'm going to find that a 15-year-old car is not generally worth $5,000. So I'm going to appoint the public defender.
Okay.
Okay. And on the charges, what is the state asking for?
The state is asking for $5,000 on count 1 and $5,000 on count 2. The state brings to attention we had EV batteries, medical battery in 2005.
Kylan Ford.
Hang on. Stop. Don't talk about
He
the
doesn't
case.
live with me. That's all I was trying to say. He stays with
All
his
right.
grandma.
Mr. Gittens, how do you wish to respond?
Judge, I would ask for pretrial release. He has no prior failures to appear, and it looks like his last conviction was in 2013.
Yeah, but he punched her or whatever, he slapped, I don't know which, his stepson and gave him a black eye.
No, ma'am. It was. If you would read my side of the statement on the paper, he was kicking.
Hang on. Don't talk about the facts.
Okay.
Just be quiet.
Just read my side.
Sir, you know, everything you say here can be used against you. That's why your attorney is suggesting you not speak about the facts.
Yes, ma'am. I understand.
Okay, it's just not appropriate to punch children in the face and give them a black eye.
Don't respond.
I have to assume what the what's in the arrest affidavit is true. And Madam Clerk, if I don't state otherwise, I do find probable cause. I will order $5,000 on count 1 and $1,000 on count 2. And there'll be no contact with the victims, no return to the location. Do you need to go back there one time to get your personal belongings?
Where, ma'am? He does.
To the
The kid doesn't. He
To
stays
your,
with his grandma. He doesn't stay there. I don't
Well-
understand what's the reason to do that if he doesn't stay there.
Okay, but his mother lives there, right?
Yeah, I had no problem with mom.
And he goes to spend time with his mother, so you can't return there. No return to the location, no weapons, firearms, or ammunition. You can return one time with a law enforcement officer to get your personal belongings. Good luck to you, sir.
Christopher Cole.
Good afternoon, Mr. Cole.
Good afternoon.
Sir, you're charged with battery of a law enforcement officer in violation of the governor's executive order for COVID-19. What is the state asking for here? Count one, he splashed the beer on the officer.
It's not a,
And count two, he said he was on lunch. He didn't seem to charge him with the open container.
they charge him with no container.
Well, that's not on my docket.
No, I don't. I wasn't charged for that.
It's
Just the two charges.
not, the 923 does not indicate that. 923 says open container in vehicle.
Well, sometimes that's an infraction.
I wasn't charged.
The state is, the reason the state is asking for that is because the way the defendant was acting through the whole thing. He was.
I know how he was acting. He was acting inappropriately.
Yes. And then ultimately, when he was given every opportunity by the police to let him go, he continued on and then, out of anger, waxed the beer into the police officer, which was intentional, which is what he was doing in the first place.
No, it wasn't. I was.
Stop. Sir, so what are you asking for?
The 5,000 in ROR on the second count.
Well, if he was on lunch, I assume, I don't know what he was doing, if he was working and someplace appropriate and then he was on lunch, then I'm not, and he was sitting in his car, I'm not sure that's a violation.
I don't. That's why I think it's ROR for the.
Well, it's ROR, but I'm going to find no probable cause without more information. On count one, I'll order $1,000. Should be able to post that. And there'll be no, I can't order no contact. Any conditions? I'll order pretrial release as a condition of the bond with no use of possession of alcohol or illegal drugs and random testing at your expense. Good luck to you, sir.
Okay, thank you.
Judge, you found no PCS to count two?
Two, right.
And you're RORing on count two?
Right.
Okay, and was the public defender appointed?
Oh, I didn't ask him. You want to get him back here, please? Thank you, Madam Clerk.
Yes.
Sir, are you asking that I appoint an attorney to represent you?
Yes, if that's possible.
He qualifies.
I'll appoint the public defender. Thank you.
All right, thank you.
Matthew Cummins.
Yes, ma'am.
Good afternoon, Mr. Cummins. You're charged with aggravated battery with a deadly weapon and carrying a concealed weapon. You were previously appointed an attorney to represent you. What are we here for today?
He was, to give you some background, he was arrested here in a warrant in Brevard County for the amounts you see, the aggravated battery and the carrying a concealed weapon. I think he's bonded on those. However, he's currently on probation in St. Lucie County and in Indian River County. He was not on site, but he's AMA. And as a result, the state is requesting, again, from both St. Lucie and from Indian River County, that probation go after them for a warrant. So far, we have not had the warrant. It hasn't returned yet, but he's still AMA.
Okay. I'm going to note for the record that you qualify under the Anti-Murder Act, so you can't be released under the fact you're on probation.
Judge, you're notating
Not
us
on
on
this-
this case?
No, not on this case. He's AMA on the case he's on probation for in the other county.
Okay, so you want me to notate that in this case though, because that's not our case.
Right. Right, and we need to hold him for locals to be resolved before he gets transported
So are
anyway,
you
right?
ordering for us to add a case then?
He has to be held on the AMA as he violated the Anti-Murder Act.
Okay, but you need to, the clerk is asking on which case is there the AMA? It's on the probation cases, but they're
It
not,
is.
there's no charge here on the probation cases.
That is correct.
So what do you want me to do?
I want you to hold him until we get something come back from St. Lucie and Indian River County. Because once you're arrested in the Anti-Murder Act, it has nothing to do with warrants. It has a question to do that you're arrested. And in this particular matter, he was on-site. He has to be on-sited because he was not on-sited.
How can he pay $100,000 bond with a public defender? Anyway, he's going to be held. I'm holding him until this case gets resolved.
So you're changing his bond to none
Yes.
on both counts?
Well, Judge, his bond, the AMA does not affect the new charges here in Brevard County. He has a
All right,
bond.
so how do you want me to do this, Mr. Gittens?
Well, I'm just saying that he can't be held on the new charges. He has a bond, and if he posts bond, then he would
He did
be on
post
bond.
bond. He's already bonded on this case, I've been told.
No, he hasn't, Judge.
He hasn't?
No, ma'am.
Oh, I thought Mr. Lockman said he
That's what I
bonded.
was told he bought. I haven't checked it myself.
All right, then leave the bonds the way they are. And we'll see what. But please note for the record that he qualifies under the Anti-Murder Act because he has a VOP on another case.
Yes, Your Honor.
All right, thank you.
Judge, I just want to make sure that it's clear that he's not being held AMA on this case.
No, you only can be held AMA on a VOP.
Right.
But I'm noting that there is I've been told by the state that there are 2 VOPs in another county, and given the nature of what's going on these days, things aren't happening as quickly as they should. So he can't leave. He can't be released from jail until things get resolved properly. Okay. Scott Dadisman.
Yes.
Good afternoon, Mr. Dadisman. You're charged with, you have 2 cases. The first is an on-site violation of probation. And the second, you're charged with giving false name or identification to a law enforcement officer and resisting an officer without violence. Are you asking that I appoint an attorney to represent you?
Please, but also I would ask you for ROR and the fact that.
Sir, I did not ask. The only question at this time is if you
Yes,
want an
ma'am.
attorney
Yes, ma'am.
appoint-
Yes, ma'am. Please.
Mr. Gittens?
Yes, he does qualify.
I'll appoint the public defender on both cases. Okay. Now, first, what is the state asking for?
As to the new law violation, the resisting, as to giving false name, $500, resisting without violence, $500. And as to the VOP, the state is requesting no bond.
Why?
Why? Because he's an individual who had every opportunity in the world to say to the police, to tell the police while he was on the boat that everything was just fine and accept the summons. Instead, he went and gave him false information and then dove in the water, and the police had to go chase him down. He's a threat to the community. What's?
All right, let me look at this prior record. Was he drinking?
I don't know, to be honest. Let me take a look.
Yeah, he's got a lot of. In 2020 alone, he has
I know.
2 trafficking in stolen property, 2 false verification of ownership, fraudulent use of credit cards, possession of burglary tools, criminal mischief, attempted burglary of a structure, burglary of a structure. Those are all in 2020. All right, on the new law violation, I'll order 500 on count 1 and 500 on count 2. On the violation of probation, I'll order no bond, and you could go in front of the judge, assigned to your case. They are having hearings for people in jail for modification of bond amounts, okay?
Your Honor, on the fact of the violation of probation, I had not done anything wrong. I was under the assumption any police contact would violate me and order. And I was given a boat, which I was homeless, and this man to work on. And the police did come up to...
Sir, sir, anything you say can be used against you.
That's fine.
And by what you're saying, you're making admissions, and you may not want to do that.
Well, the fact is...
Just by what you're making admissions.
It's not the time to discuss it.
You need to talk to your attorney rather than in open court. I just don't want you to hurt yourself, which is what you're doing.
I'm losing my home. I have the boat was my home, and without RORing, I had no violations of anything. I have no home, and
well, maybe you should stop getting yourself in trouble.
Judge, I would also
That would help.
Sorry, Judge, I would also
Given
point
all
out.
the convictions. Go ahead.
Judge, I would point out he has no prior failures to appear, even in light of his history. I'd ask that the court set bond on the VOP.
No, just go in front of the judge assigned to the case and ask them. Good luck to you, sir.
Come on, David.
Here you go, Gordon.
James Gordon.
Yes.
So you're charged with grand theft of a motor vehicle and burglary of an unoccupied structure or conveyance. Are you asking that I appoint an attorney to represent you?
Yes, ma'am.
He qualifies.
I'll appoint the public defender. Now, this is an arrest warrant. Any reason I shouldn't order the amounts ordered by the judge?
No, Your Honor.
Judge, I would ask for a modification. He has no prior convictions and no failures to appear. I don't know if the judge was aware of that when signing the warrant.
I don't see a PTR sheet. Wait a second. I don't have a PTR sheet. Do you have one?
No.
Do you have a PTR sheet?
Yes, I do.
Okay, it shows no convictions?
No convictions, and it shows that he has a pending grand theft of a motor vehicle and resisting without violence in Volusia County. Next court date, May 5th. And no failures to appear, not on probation.
All right, you're right. The judge probably did not know that. I'm going to reduce each count to 5,000. And no return, says no return to Satellite Beach unless to your personal home. Okay, I'll just leave it at that. I assume Satellite Beach is where this occurred. So. All right, good luck to you, sir.
All right.
Good afternoon, Mr. Hutchinson.
How you doing, man?
Sir?
Ma'am?
Sir, you're charged with petty theft.
Yes.
Are you asking that I appoint an attorney to represent you?
Yes, ma'am.
He qualifies.
I'll appoint the public defender, and I'm going to order pretrial release with no use of possession of alcohol or illegal drugs and random testing at your expense.
Yes, ma'am.
Good luck to you, sir.
No, that's right there. Go ahead. No, he's got a CPT.
I assume you'd speak up if you objected.
Well, he's in custody, so I'm not, that's why I'm not.
He's not? He is?
Right there.
On something else, Hutchinson?
Yeah, he has 2 pending cases, but he's been in custody since April 5th. So I don't think he's going anywhere.
Mr. Gittens, let's go back to Mr. Hutchinson. Would you like a bond?
If I can have a minute to chat with him?
Okay, because if he's in custody on something else, he may be wanting to get time.
Yes. Yes, Judge, I'd ask that the court set a minimal bond of $100.
If I, $100 bond, cash only. Any objection?
That's fine.
Judge, I would ask that it be cash or surety.
It costs $100 with a surety agent. If it's cash, then it's going to cost $100 either way.
I do understand that. I do understand. I'm sorry. I do understand that. However, he may be able to get a bondsman to bond him out easier than having someone bring $100 to the jail to post a bond.
Okay, fine. Cash or surety. He would save $100, but okay. Christopher Illenfeld?
Yes, ma'am.
Are you removing random testing?
Yeah, I guess so. Actually, he was stealing. He's going to be in the jail, so there's no point. Yes, just do the $100.
So you're removing no alcohol, no drugs as well?
No, you could say no use of possession of alcohol or illegal drugs, but you can leave off the random testing.
Yes, thank you.
Mr. Illenfeld, you're charged with battery, domestic violence, breach of peace, disorderly conduct, and false imprisonment. Now, there was definitely PC on the breach of peace, disorderly conduct. I don't know that it's battery, domestic violence. He grabbed her shirt. And I guess that's the false imprisonment because he pulled her in and wouldn't let her leave for at some period of time. But I'm not sure that qualifies as domestic violence with the information that's there.
An unwanted touching.
Well, he didn't touch her, though. It didn't say.
Clearly, it's an unwanted touching.
But he didn't touch her.
I think that his shirt is when you don't have to necessarily hit the flesh or
It's really a little. It said he grabbed her shirt, so maybe that would qualify for the false imprisonment because she couldn't leave, stopped her from leaving, but. What do you say, Mr. Gittens?
If I may say something too.
I don't have any argument.
All right, apparently you do find PC on that, so I'll
May I-
assume I'm wrong.
May I say something, ma'am?
Sir, I would not talk about the facts of the case if I were you.
No,
because
ma'am. I
everything
will.
you say
I will
here-
not speak of that.
You-
I just wanted to
you
say.
really-
Sorry, ma'am.
You know, you'd probably be better off not saying anything.
Okay. Yes, ma'am.
Okay, any problem with pretrial release?
Yes.
Why? I'll do the random testing.
Yeah, the problem I have is this. One, I think that
Did you look at his record?
I did. I did look at his record. I also looked at the fact that somebody, the one question that you've asked, and I agree with in many ways, and that is the danger to the community. Well, the young lady that was involved in this, who was trying to get away from him, he prevented her from doing that. And then there were neighbors that see him continue the argument outside. And there's situations where the people are put into harm's way. And the notion of just releasing him, one, misses the whole point. And two, and that you can't do these things without something happening to you. And two,
He's
this
been in jail, so.
this is a third-degree felony, false imprisonment.
Okay. Okay, given his lack of record, I'm going to order pretrial release with no contact with the victim, no return to the victim's residence or place of employment. Do you need to return one time to get your personal belongings?
No, ma'am. I can have somebody do that for me.
Okay.
If that's
no
okay.
No weapons, firearms, or ammunition. And then I'm going to order a sentinel monitor. That should allay your concerns.
Yeah, that's yes.
That works then?
That works.
Okay. A sentinel monitor, you can't go within 1,000 feet of where she lives or where she works. And there'll be also no use or possession of alcohol or illegal drugs and random testing at your expense.
Yes, ma'am.
Okay?
Judge, did you appoint the
You have no
public defender?
Did I? Mr. Eiteld, are you asking that I appoint an attorney to represent you?
Yes, please.
He qualifies. Yes.
I'll appoint the public defender. Thank you, Madam Clerk.
And it was PTR, all counts, no monetary, correct?
Correct.
Thank you.
All right. All right. Is Blake Jackson. Good afternoon, Mr. Jackson.
Good afternoon, Ms. Atkins.
Sir, you're charged with possession of a concealed firearm by a convicted felon, shooting or throwing a deadly missile into an occupied or unoccupied dwelling, discharge of a firearm in public or on residential property, improper exhibition of a dangerous weapon or firearm. I will tell you, and this is an arrest warrant. If it was me, I would have ordered higher amounts, but I'm going to order what's in the arrest warrant. 35,000 count 1, 25,000 count 2, 2,000 count 3, and 2,000 count 4. And there'll be no contact with the witness, no contact with the victim. If there's no weapons, firearms, or ammunition. Any other conditions?
No, Your Honor.
No return to the location. Okay. Good luck to you, sir.
Yes, ma'am.
Judge, regarding counsel, he does not appear to qualify.
Oh.
He
Wait a
indicates.
second, Mr. Jack. I need him back. Thank you. Go ahead, Mr. Gittens.
Judge, he indicates that he makes $1,300 per week with one dependent.
Mr. Jackson, are you asking that I appoint an attorney to represent you?
Most likely I'm gonna end up getting a private attorney, so I just.
Do you know who you're
didn't
going to
bother.
hire?
Most likely Harley
Do you know?
Gooden.
Do you want me to call Mr. Gooden now?
I mean, I can have my family contact him.
Okay, fine. All right, so we won't appoint an attorney today, okay?
Yes, ma'am.
All right, good luck to you.
Thank you.
Kente Jenkins.
Yes, ma'am.
Mr. Jenkins, you're charged with...
Judge, he'll waive
Are you
reading of the charge. Yes, he'll waive
Okay.
reading of the charge.
Okay, Mr. Jenkins, are you asking that I appoint an attorney to represent you?
Yes, ma'am.
He qualifies.
I'll appoint the public defender and your attorney asked to waive reading of the charge, and the bond amount is $75,000. And there'll be no contact with the victim, no return to the location.
Excuse me, ma'am. At the location, she
Yes,
does.
sir.
The victim doesn't live there. She actually is actually somewhere else. She's actually somewhere else.
Is that where you live?
Yes, ma'am.
Can anybody verify that she lives in a different residence? Okay, this is what I'll say. You can return to the location with a law enforcement officer, and if the law enforcement officer can determine that she no longer lives there, then you can return.
Okay.
Now, is this a domestic violence? Can I order a sentinel monitor?
It sounds like it is, Your Honor.
Right. Do you, Mr. Gittens, you have any objection to a finding that it's domestic violence?
No, based on the charge, it would appear to be.
Okay, then I'm going to order a sentinel monitor. You can't go within 1,000 feet of where she well, I assume she's a child, so 1,000 feet.
He's 15 years old.
Okay, 1,000 feet of where she goes to school, where she works, any place she frequents. And no contact with any witnesses. Good luck to you, sir.
Your Honor, before he leaves,
Yes.
he's currently out on bond on case number 19-56622, CFA, which is a dweller's HDO, resisting without violence. The state is requesting revocation of his bond.
None on those charges. No. All right, thank you.
Thank you,
Good
Your Honor.
luck to you, sir.
Thank you.
Chase Jett.
Yes, ma'am.
Good afternoon, Mr. Jett.
Good afternoon, Your Honor.
Sir, you have two cases. The first, you're charged with reckless driving, first offense, retail theft, under 750, 4 civil infractions, and on the second case, you're charged with an on-site violation of probation. Are you asking that I appoint an attorney to represent you?
Yes, Your Honor.
He qualifies.
I'll appoint a public defender on both cases. What is the state asking for?
As to count one, the state is requesting 1,000. Count two, the state is requesting 1,000. As to the VOP, the state is requesting 25,000.
I need to look at this again. Excuse me. Alright. $1,000 count one, $1,000 count two on this first case, on the new law.
Judge, as to the
And no
VOP,
return. No, I'm not finished yet. No return to the location of the theft. That's CVS. And no weapons, firearms, or ammunition. Okay, now on the VOP, what is? Yes, Mr. Gittens.
Judge, on the VOP, defense would ask for $7,500. He has no prior failures to appear.
Okay, 7,500.
Your Honor, I have to tell you that my first inclination was no bond, and that's where I should have stayed with. The fact is that his criminal record includes a attempted burglary in 2012, grand theft, petty theft. He's had a violation of probation on those. His felony petty theft in 2015, dealing with stolen property, and then false verification of ownership. He goes into during this COVID-19 problem, he goes in and takes a disinfecting machine that's worth almost $500 out of a CVS pharmacy. You know, it really should be no bond.
All right, I'll make it 10,000. Okay. Good luck to you, sir. Are you John Kleinschmidt?
Correct.
Okay, good afternoon, sir.
Good afternoon.
You're charged with battery domestic violence. Are you asking that I appoint an attorney to represent you?
If I qualify.
Judge, he
Excuse
says
me?
he makes $800 a week with no dependents and has $7,000 in equity in a vehicle.
All right, what kind of vehicle do you own?
Yeah, it was probably high. It's a 2002 Ford pickup.
Okay, it does not have $7,000 of equity.
No.
The car is almost 20 years old. Okay, and he earns how much a week?
He said 800 with no dependents.
And what's the cutoff? It's about 500, isn't it?
All right, 491.
Yeah. It doesn't seem like you qualify for a public defender based upon your income, sir.
That's
Is the
right, Your Honor.
800 your net or your gross? Is that what your checks are for?
No, that's my net.
That's your net. Yeah, you're non-indigent based upon that. So you'll have to hire a private attorney.
Yes, ma'am.
Okay. Now, this is a battery domestic violence. Was there alcohol involved?
I'm sorry, Your Honor.
Was there alcohol involved on this one? I didn't make a note.
There's no indication.
It says no for drugs, but it doesn't say anything for alcohol. Let's see if it says it in there. All right. What is the state asking for?
$1,000.
All right. $1,000. No contact with the victim. No return to the location. No weapons, firearms, or ammunition. Wherever, we'll say no return to the victim's home or place of residence or place of employment. And any place you know of that she frequents. All right. Good luck to you, sir.
Thank you.
Mr. Lovell?
Hey, Your Honor, this is the very last group. They need to be sworn in, starting with Mr. Lovell.
Okay. Good afternoon, ladies and gentlemen. We are here for initial appearances. The purpose of this hearing is to determine if there was probable cause for your arrest, what your bond should be, and whether an attorney should be appointed to represent you. You do have the right to remain silent, so wait and speak with your attorney in private about the facts of your case. You'll also have the right to be in contact with your family or attorney by telephone. If you are here on a warrant, whether it is for failure to appear, violation of probation, or an arrest warrant, the judge who issued the warrant has already set the bond amount, and you will generally need to appear before the judge assigned to your case to request a modification of the bond amount. Will everyone who's here for court today please raise your right hand? You swear affirm testimony you give. Raise your right hand. You swear affirm. Sir?
Oh, I'm sorry.
Raise.
I did raise it.
You swear affirm testimony you will give will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Yes?
Yes, ma'am.
Everybody?
That's what I said.
Okay, thank you.
All right, put it in.
Mr. Lovell, you're charged with driving under the influence, possession of a controlled substance without a prescription, possession of cocaine, altering or destroying or concealing evidence in the process of an investigation, use of possession of drug paraphernalia. Are you asking that I appoint an attorney to represent you?
Yes, ma'am.
Judge, I believe he's indicated he has no income, but he has $40,000 in the bank. That's 40.
So you have $40,000 in the bank?
What's it? Yes, ma'am. That's
What
from
kind of account is that?
It's a savings account. It was from my father when he died. I got an inheritance.
Okay, you'll have to hire, you're non-indigent, you'll have to hire a private attorney. Okay.
Yes, ma'am.
Let's see. What is the state asking for?
The schedule amounts, Your Honor.
No. I don't think so. Here's the money. I'm inclined to order pretrial release with drug testing. Any problem with that?
He was driving 90 miles an hour,
Yeah, I'm not saying it wasn't dangerous.
you
what
know,
it was doing.
and get out to your discretion.
He was on, yeah, he was on Barton. Is this the one he was on Barton Boulevard?
No, ma'am.
No? Oh, that must have been a different one, sorry.
And the problem the state has is the fact that he admits to having the Xanax, taking Xanax, and and then he has found with cocaine in his sock that he's trying to get rid of. I just don't think that's PTR material.
Not normally, it isn't. Well, he can bond out. All right, you're right. I'll order 1,000 on count 1, 1,000 on count 2, 1,000 on count 3, 1,000 on count 4, and 1,000 on count 5. And there'll be pretrial release will be a condition of the bond with no use of possession. It was all drugs, right? With illegal drugs and random testing at your expense. Good luck to you, sir.
Thank you very much.
Judge, it's random testing for alcohol and drugs, or did you say just drugs?
Just drugs. There was no alcohol involved here.
Yes, ma'am.
Was there? We didn't see any alcohol. It was all drugs. Darius McCullough.
Yes, ma'am.
Mr. McCullough, you're charged with aggravated fleeing and eluding, possession of cocaine, possession of ecstasy, keeping a place for drugs, possession of cocaine, leaving the scene of a crash, 3 counts, resisting an officer without violence, reckless driving, and refusal to sign the summons. Are you asking that I appoint an attorney to represent you?
Yes, ma'am.
He qualifies.
I'll appoint the public defender. What is the state asking for?
The amounts indicated on the
How
docket,
can
Your
you
Honor.
leave the scene of the crash 3 times? And it doesn't make. It was all one continuous incident, don't you think?
Well, I just think that when you keep changing locations, as you bouncing from one building to another or fence to another.
Yeah, but it's one continuous.
Yeah, that's fine. I don't have any.
All right. On the, Mr. Gittens, I'll state what I'm going to do, and then if you want to argue, feel free.
Yes.
I'll order 15,000 on count 1, 1,000 on count 2, 1,000 on count 3. Do you ever really go forward with that next charge?
It may or may not, Your Honor.
ROR on count 4, or PTR. Is there 2,000 on count 5, 1,000 on count 6, ROR on count 7 and 8. It doesn't really matter if it's 500 or 1,000, that's the problem. ROR on count 9, but 1,000 on count 10. No, I'll leave the 1,000 on count 9, 1,000 on count 10, and ROR on count 11.
I'm sorry,
All
Judge,
right.
can you repeat the last part for 9, 10, and 11?
Sure. 9 is 1,000, 10 is 1,000, and 11 is ROR.
Thank you.
So we have 3 RORs on this and 1 PTR. And then all the counts that exist, in addition to the PTR count, will have a condition of the bond of pretrial release with no use of possession of illegal drugs and random testing at your expense. Good luck to you, sir.
Yes, ma'am.
That was McCullough. Next, we're up to Kenneth O'Neill. Mr. O'Neill, you have 2 cases. The first, you're charged with burglary of an unoccupied dwelling and petty theft, and the second case is a violation of probation and on-site. Are you asking that I appoint an attorney to represent you?
Yes, ma'am.
He qualifies.
I'll appoint the public defender on both cases. What is the state asking for?
The state is asking on, for the case ending in 309, as the burglary of an unoccupied dwelling, 5,000, as the petty theft, 1,000, and on the case ending in 949, the state is requesting 5,000.
Okay, he did go into someone's house. It's not just a warehouse somewhere. It was somebody's house.
It's an occupied dwelling is 15,000. Any other burglary is 5,000. That's the schedule. Let's put it that way.
All right, 5,000 on count one. The petty theft will do 1,000. And on the violation of probation, what did you ask for?
5,000.
Okay, 5,000.
Judge.
Any objection?
Judge, I would object to the on-site. I would ask for 3,000 as the underlying charge.
I was going to do 12,000 on the on-site until I heard Mr. Lochran ask for 5, so.
I would just point out that the underlying charge is a misdemeanor battery.
Okay. Well, you're on probation and then you get a new law violation. That's a problem. So I'll order 5,000 on count one, 1,000 on count two. No contact with the victim, no return, either victim. No return to the location, no weapons, firearms, or ammunition. And anything else the state's asking for?
No, Your Honor.
Okay. Good luck to you, sir. Michael Paul.
Yes, ma'am.
Good afternoon, Mr. Paul.
How you doing, Judge? How you doing, Judge?
Sir, you're charged with trespass in structure or conveyance and use or possession of drug paraphernalia. Are you asking that I appoint an attorney to represent you?
Yes, ma'am.
He qualifies?
Yes, he does. Sorry.
I'll appoint a public defender. What is the state asking for here?
500 for each count, Your Honor.
Okay.
Would I be able to?
Okay, I'm going to order pretrial release with no use of possession of illegal drugs and random testing at your expense, and no return to the location.
Yes, ma'am.
Good luck to you, sir.
Thank you.
Judge, it was no legal drugs, not alcohol, correct?
Right, I'm not allowed to say alcohol.
I
no
know,
alcohol.
I wasn't sure if I heard you or not, sorry. Thank you.
Trevor Stillwell?
Yes, ma'am.
Is that you, sir?
Yes, ma'am.
Sir, you're charged with felony petty theft with 2 or more prior convictions.
Yes,
Are you
ma'am.
asking that I appoint an attorney to represent you?
Yes, ma'am.
Judge, he qualifies. However, I need to ask for regional conflict counsel. We'll have a conflict with Hannah Johnson.
Okay, I'll appoint regional counsel.
Excuse me, ma'am. For my other, this is my third one that I have. That they hit me with. I already have. I think it's registry counsel. I already have. I think his name is Kevin Reynolds, if I'm not mistaken. And they gave me him. I have him on 2 other felony petty thefts that I have, and.
All right, there must be a conflict for regional. I'll appoint registry, and I'll appoint, what's his name? Reynolds, Mr. Reynolds.
Yes, ma'am. And Miss Atkins.
Any objection?
I'm sorry. Sorry to cut you off.
The conversation we had last time that Mr. Stillwell was through here, and that is that apparently Mr. Reynolds is not necessarily on the registry council for anything other than misdemeanor. But he seems to be representing Mr. Stillwell, so I don't know where that goes. I just wanted to let the court know that.
All right, I'm not sure Mr. Reynolds can do it because he's not on the registry for felonies.
Okay, so what are they supposed to do about that? Because mine are felonies, so I mean, they gotta get. I mean, I see you do this a lot, so I mean, if you can't do it, then who can do it?
Okay.
I mean, with all
I'll
the
appoint
corona.
registry.
Okay, I'm sorry, ma'am.
I'll appoint registry counsel, and they'll have to appoint whoever they appoint because Mr. Reynolds is not on the registry for felonies.
Okay, and ma'am, I have a conflict attorney on like some of my other charges, but I don't understand how I'm allowed to have conflict attorney on some charges, but not all my charges. Shouldn't it be I'm not allowed to have a conflict attorney on any charges, if I'm not mistaken? I mean, I don't know that, but I mean.
Apparently, the public defender and regional counsel have a conflict, so therefore I have to order registry.
Right.
And that's what I'm doing.
No, that's yes, ma'am. I understand that. I'm saying I have a conflict attorney on some other charges, but I have a conflict with the conflict attorney on, obviously on at least one charge. So I don't understand why I wouldn't have a conflict on all the charges.
Well, I'm sure the attorney, if there's a conflict, will let the court know.
Okay? Okay. Yes, ma'am. Yes, ma'am.
Oh my God! Look, what is the state asking for here?
2,000.
Boy, is that a gift! Look at
He's in custody. He's been in custody.
All right, $2,000 for the bond. No return to the location. No weapons, firearms, or ammunition. And no contact with any victims. That means anyone who works at Home Depot. Good luck to you, sir.
Thank you, ma'am.
Paul Young.
Yes, Your Honor.
Good afternoon, Mr. Young.
Good afternoon,
You're charged with battery, domestic violence. Are you asking that I appoint an attorney to represent you?
Yes, Your Honor.
Mr. Gittens?
He qualifies.
I'll appoint the public defender. What is the state asking for?
If you give me just 1 second, Your Honor.
Sure.
I apologize.
No problem. It was his sister.
Yeah, that's what I was trying to remember this one.
Yeah, I made a note.
Oh, he snatched the hat off. The PTR.
PTR?
Yes.
All right, I'll order pretrial release with no contact with the victim, no return to the location, no return to where the victim lives or works, no weapons, firearms, or ammunition. Good luck to you, sir.
Thank you, Your Honor.
Jose Fernando. This
Hey,
is
Your
a
Honor,
file R01.
Mr. Jose Fernando speaks no English, so we're going to need to do the language line on him, and then we have another one who needs language line. So what I'd suggest is to do Mr. Ricardo Gordo, and then go ahead and do the 2 language lines, and then do the medical, and we're done.
Okay. That's
Mr.
fine.
Gordo?
Good afternoon, Mr. Gordo.
Good afternoon, ma'am.
So you're charged with felony battery or domestic battery by strangulation and false imprisonment. This is a file ROR. Did the state file?
ROR, Your Honor.
Okay, you'll be ROR today. You'll be released, but the previous conditions still apply. There's no contact with the victim, no return to the victim's residence. You can go back 1 time with a law enforcement officer to get your personal belongings. Good luck to you, sir.
Thank you, ma'am.
All right. Now we have the 2 where we need the interpreter. And
Yes.
that would be
Mr. Fernando and Mr. Fohia. You want to do Mr.
Prohia.
Which one do you want to do first, Your Honor?
Let's take care of Mr. Fernando first.
Yes, Your Honor. Fernando?
But we need the language line.
I'm dialing it now, Judge.
All right, thank you. We don't have a Spanish-speaking deputy, do we, today?
Unfortunately not today, Your Honor. Unfortunately not.
Your Honor, while we're doing that, this is Michelle. Can we readdress Cummings, please? Number 7 on your docket.
Okay. Okay.
Okay, on this
I know.
case, you left the bonds as they were, but you indicated that he could not bond out until he resolved the AMA matter.
Yes, until he resolves, the state is asking that he not be released because he's AMA on some VOPs out of county.
Right.
And they're waiting for the VOPs to come through.
They're not going to serve him with the VOP until he either bonds on this case or his case is resolved. So that AMA issue is not going to get resolved until he does one or the other of those two things. Either bonds on this case or this case is resolved. So he cannot address the AMA matter prior to bonding.
Okay.
So.
That's fine.
Is that
Then
okay?
we just leave the bonds as, I don't have any choice.
Okay, I just wanted to make sure you understood that, because we did check into it, we did check a teletype, and that county indicated that there is a hold, and it would be taken care of after the defendant either bonded or resolved it. So we just wanted to make sure you were aware of that. Thank you.
As long as there's a hold, Michelle, as
Yes.
long as there's a hold, that's
Yes,
it.
there's definitely a hold, Mr. Lockern. That's taken care of. That is out there.
Thanks very much.
You're welcome.
Welcome to Language Line Solutions. Please enter your 6-digit client ID. For Spanish,
Mr.
press
Fernando.
1. For other, press 2. Please enter the 5-digit extension number. Please hold for an interpreter.
Your Honor, did Shannon speak to you about the court costs?
Thank you for calling Language Line Solutions. This is Leo, ID number 221959. I will be your Spanish interpreter for today.
Thank you. Mr. Interpreter, will you please raise your right hand? You swear affirm you swear affirm that the translation you provide will be a true and correct translation of what is being said?
Yes, I do.
Okay, thank you. Will you state your name and affiliation?
¿Podría usted decir su nombre y afiliación?
José Fernando.
José
No, I
Fernando.
was talking to you. I was talking to you, Mr. Interpreter. Will you please state your name and affiliation?
I apologize. My name is Leo, and I am with Language Line Solutions.
And Madam Clerk, did you get the number?
It wouldn't hurt if he would repeat it for us, please.
Please
It is
repeat the number.
221959.
Thank you.
Thank you.
You're welcome.
Oh, and this is Jose Fernando, is that correct?
Hola, yo voy a ser su intérprete. ¿Es usted José Fernando? ¿Es correcto?
Sí.
Yes.
Okay, Mr. Fernando, you're charged with leaving the scene of an accident. Oh, wait a second. This is a file ROR. Did the state file?
Yes, Your Honor.
Did the state file as charged?
Yes, count 1 is leaving the scene of an accident, of a crash resulting in injury. Count 2 is resisting an officer without violence. And count 3 is driving motor vehicle without a license.
Okay, and all three were charged?
Yes, Your Honor.
Okay, Mr. Fernando, the charges were filed just as they were originally stated.
señor Fernando, se le están haciendo cargos por parte del Estado de huir de la escena del accidente, ocasionar lesiones en segundo grado, evadir a un oficial de policía y el manejar un vehículo motorizado sin la licencia. Entonces, todos los 3 cargos se han puesto como se han leído.
Okay, so the bonds and the conditions remain as stated at your first appearance.
Entonces, la fianza, ¿sí? Y las condiciones permanecen igual como su primer audiencia.
Do you have any questions, sir?
¿Alguna pregunta, señor?
No.
Buena suerte.
Ok, gracias.
Thank you.
Okay, Mr. Interpreter, don't hang up. We have another case.
Thank you.
Okay, the next case is Carlos Projilla.
Saludos, yo voy a ser su intérprete para esta llamada.
Okay, Mr. Projilla, I understand you would like to enter into a plea agreement today, is that correct?
Pero, señor Cogilla, tengo entendido que pues usted accedió a unos cargos, un acuerdo de los cargos. ¿Es esto correcto?
Sí.
Yes.
Okay, the offer from the state is an adjudication of guilt, credit for time served. Can someone provide me with the credit?
We have 49 days, Judge.
49 days credit time served, court costs, costs of prosecution, and costs of defense. Do you wish to accept those terms?
Bueno, señor Trujillo, la oferta por declararse culpable es adjudicar los cargos, tomarle crédito por los días que ya ha pasado en la cárcel. Se toman 49 días de crédito. Pagaría usted los costos del tribunal, costos de la dependencia que lo está acusando. ¿Está usted de acuerdo con estos cargos?
Sí.
Yes.
Okay. So to the charge of driving while license suspended with knowledge as a second offense, how do you wish to plead?
Muy bien. Entonces, con los cargos de manejar con la licencia suspendida como segunda ofensa, ¿cómo se declara?
Culpable.
Guilty.
Did you hear and understand the terms of the plea?
¿Usted escuchó y entendió los términos de este acuerdo por declaración culpable?
Sí. Sí.
Yes.
How old are you, sir?
¿Qué edad tiene usted, señor?
Yo 51.
I am 51 years old.
Okay, and what's your level of education?
Muy bien. ¿Y cuál es su nivel de educación?
Yo 12 grados.
12th grade.
Okay, have you ever been diagnosed or treated for any type of mental illness?
Muy bien. ¿Alguna vez usted le han dado tratamiento o ha sido diagnosticado por alguna enfermedad de salud mental?
No.
No.
Have you taken any drugs, legal or illegal, or consumed any alcoholic beverage within the last 24 hours?
¿Usted ha consumido alguna droga, legal o ilegal, o ha consumido alguna bebida alcohólica en las últimas 24 horas?
No.
No.
Do you believe that you are thinking clearly at this time and understand exactly what is taking place?
¿Cree usted que está comprendiendo exactamente lo que está ocurriendo en este momento?
Sí.
Y lo que le estamos diciendo?
Sí.
Yes.
Do you understand that you have the right to have an attorney appointed for you? And by entering this plea, you're waiving that right?
Usted comprende que tiene usted el derecho a que un abogado lo represente y a que usted al declararse culpable en este acuerdo, usted está renunciando a este derecho.
Sí, yo sé.
Yes, I
Do you,
know.
do you understand the maximum penalty for this charge would be, is it charged as a second or first degree? A year in jail?
¿Comprende usted que la pena máxima para este cargo en segundo grado es de hasta 1 año en la cárcel?
Sí.
Yes.
Has anyone promised you anything for entering this plea other than what your plea agreement provides?
¿Alguien le ha prometido algo aparte de los acuerdos en la declaración de culpabilidad que
No.
se le indicaron?
No.
No.
Do you understand that if you went to trial, you would have certain constitutional rights, including the right to confront and cross-examine all witnesses called by the state, the right to subpoena any witnesses you wish to call to have them testify at trial, the right to remain silent and not incriminate yourself, and the right to be represented by counsel?
¿Comprende usted que al declararse culpable, pues pierde usted ciertos derechos, como el derecho de confrontar y cuestionar todos los testigos que están en contra de usted? Tiene el derecho de cuestionar los testigos que son proporcionados por el Estado. Está renunciando al derecho de permanecer callado y no declararse culpable y no incriminarse, y tiene el derecho también de recibir consejería por parte de un abogado.
Sí.
Yes.
Do you wish to waive those rights and have me accept the plea?
¿Desea usted renunciar a estos derechos y desea que yo acepte esta declaración de culpabilidad?
Sí.
Yes.
Okay, do you understand that if I accept the plea, you waive the right to appeal if I impose a lawful sentence?
¿Comprende usted que si acepto la declaración, usted está renunciando a su derecho de una apelación si pongo una sentencia justa?
Sí, entiendo.
Yes, I understand.
Do you understand that if you're not a U.S. citizen, you could be deported as a result of this plea?
¿Comprende usted que si usted no es ciudadano de los Estados Unidos, puede usted ser deportado como consecuencia de esta declaración?
Sí, entiendo.
Yes,
If
I
you were
understand.
if you were to be deported as a result of this plea, would you still accept the terms?
Si usted fuera a ser deportado como resultado de este acuerdo por declaración de culpabilidad, ¿usted aún así acepta los términos?
Sí.
Yes.
Okay, do you understand that if you get 3 driving while license suspended charges and/or DUIs or certain other offenses, you become a habitual traffic offender and lose your license for 5 years?
¿Comprende usted que si se le encuentra manejando mientras tiene la licencia suspendida por 3 ocasiones o por manejar bajo la influencia del alcohol y otras multas de tráfico, se le considera un criminal habitual y se le puede suspender la licencia hasta por 5 años?
Sí, yo entiendo eso. Yo no bebo alcohol.
Yes, I understand that. I don't drink alcohol.
Okay, but if you get 3 driving while license suspended charges, you become a habitual traffic offender and lose your license for 5 years, even if there's no alcohol.
Sí, pero si se le encuentra o se le pone un cargo de manejar mientras su licencia es suspendida por 3 ocasiones, se le considera un criminal habitual y se le puede suspender la licencia, revocar la licencia por hasta 5 años, aunque no haya alcohol involucrado.
Entiendo.
I understand.
Based upon your responses, the court finds that you were intelligent and competent, understand the consequences of your plea, willfully and knowingly waived your right to a jury trial and all the constitutional rights I explained to you, and I'll accept the plea.
Bien, basado en la conversación, el tribunal encuentra que usted fue lo suficientemente inteligente y competente como para comprender que usted está renunciando a sus derechos de un juicio por parte de un jurado y renunciar a todos los derechos constitucionales, y voy a aceptar su declaración de culpabilidad.
And I'll enter the following. I'll adjudicate you guilty to the driving while license suspended. Order 49 days in the Brevard County Jail with credit for 49 days. Court costs as determined by Collier County. Cost of prosecution and cost of defense. And you'll have 6 months to complete your obligations.
Muy bien, en este caso pues voy a aceptar el cargo enmendado de manejar con la licencia suspendida, lo cual se le va a poner la sentencia de 49 días en la cárcel. Se le va a dar crédito por ya cumplir 49 días en la cárcel. Los costos del tribunal van a ser determinados por el condado. Tiene que pagar los costos de la acción judicial y los de su abogado defensor. Tiene usted 6 meses para poder cumplir con estas obligaciones.
Okay, you have 30 days to appeal your sentence.
Tiene usted 30 días para hacer una apelación a la sentencia.
And buena suerte.
Dale una pregunta ahí. Hello.
I do have a question here.
Yes?
El problema que yo tenía en NAIPO, ya eso, yo tengo hold de NAIPO todavía.
I'm sorry, this is the interpreter. I wasn't able to understand the question. May I ask him to repeat it, please?
Sure.
Señor, le pido una disculpa. ¿Puede usted hablar un poco más claro y despacio y repetir la pregunta?
Que si yo me voy para la casa hoy, porque hay...
I would like to know if I am going home today.
If there is nothing else holding you, you should be released today.
Si no hay nada más que lo esté deteniendo, sí se le daría la libertad hoy.
Okay. Thank you.
Your Honor, if I may, this is Michelle.
Yes.
Your Honor, we would like to dismiss the out-of-county case because that is in reference to this case that he just pled on. So we have our Brevard County out-of-county, 2020 CF 17983.
So ordered.
Okay, and Your Honor, also he is in here, I believe, on a failure to appear, but Collier County is not showing that in their records. Are we able to make a notation that if there is a failure to appear, that that be dismissed?
So ordered.
Okay. I think that covers it all. Thank you. And then he needs to be fingerprinted on the dwell list.
Yes.
Thank you, Judge.
Right here's and all this is true. And what do you have for me to? And all this is true. I believe we're finished, is that correct?
We have Mr. Kimball, Mr. John Kimball. If you could just give us a minute to clear the courtroom, we'll bring Mr. Kimball in.
Okay.
Digital will be on a
I'm
short
sorry.
recess, Digital.
And I'm sorry, this is the interpreter. Do you still need me to remain on the line?
No, sir. Thank you very much, Mr. Interpreter.
Thank you for using our services, Your Honor. Have a great rest of your day.
Right.